Question 1. Government-to-government trade dispute. A Canadian engineering firm is involved in a large infrastructure project in the United States. During execution, new U.S. regulations are introduced that significantly restrict imported materials from Canada. The firm's client argues that these measures violate obligations under CUSMA. The Canadian government is asked to intervene on behalf of affected firms. Diplomatic discussions fail to resolve the issue within a reasonable timeframe. The firm seeks clarity on how such disputes are formally addressed at the international level. What is the most appropriate dispute resolution mechanism? A. Initiating a civil lawsuit in a U.S. federal court claiming breach of contract and requesting damages for economic losses caused by regulatory changes. B. Requesting the Canadian government to trigger a formal state-to-state dispute resolution panel under CUSMA to assess whether the U.S. measures violate treaty obligations. C. Filing a complaint with a provincial engineering regulator in Canada arguing that the U.S. actions undermine professional practice standards. D. Pursuing mediation directly between the engineering firm and U.S. regulators without involving either federal government. Correct answer, B. Explanation: the correct answer is B. Think like an arbitrator judge. First, classify the dispute properly. The issue is not a contract dispute. It is not about engineering practice or licensing. It is about whether one country, US, violated a trade treaty with another country, Canada. That makes it a government-to-government, state-to-state, trade dispute under CUSMA. Why B is correct? B. Requesting the Canadian government to trigger a formal state-to-state dispute resolution panel under CUSMA. This matches exactly how such disputes are handled. Only governments, not private firms, can bring treaty disputes. CUSMA provides formal dispute panels. Panels determine whether treaty obligations were violated. If violation is found, countries must comply or face consequences. This is the legally correct and structured mechanism. Crossmark why the other options fail. Crossmark A. U.S. Federal Court Lawsuit. This is a private contract legal route. The issue is not breach of contract, but government regulation. Courts do not adjudicate treaty violations between countries. Wrong jurisdiction plus wrong type of dispute. Crossmark C. Provincial Engineering Regulator Complaint. Regulators deal with licensing, professional misconduct. They cannot address international trade barriers. Completely irrelevant to the dispute type. Crossmark D. Mediation with U.S. regulators. Sounds reasonable but private firm cannot negotiate treaty compliance. Regulators cannot override national trade obligations. The issue requires federal-level intervention. Lacks authority and legal standing. Key NPPE insight, very important. When you see government intervention, treaty violation, country versus country issue, immediately think state-to-state dispute mechanism under a treaty, CUSMA panel, not courts, regulators, private negotiation. Final one-line rule. Private parties may be affected, but only governments can enforce treaty rights. Question 2. Investor-state versus state-state distinction. A US-based investor has partially funded a Canadian renewable energy project. After a policy shift, provincial authorities impose new restrictions affecting project profitability. The investor claims the measures are unfair and inconsistent with prior expectations. The investor explores dispute mechanisms under bilateral trade agreements. However, there is confusion about whether investor-state arbitration is available. The engineering consultant is asked to advise on the most realistic pathway. What is the most accurate response? A. The investor can directly initiate investor-state arbitration under CUSMA, as all trade agreements automatically include such provisions for private investors. B. The investor must rely on domestic Canadian courts or encourage the U.S. government to initiate a state-to-state dispute, as investor-state mechanisms are largely limited or removed under CUSMA. C. The investor can bypass all formal mechanisms and directly impose financial penalties on the Canadian project through contractual clauses. D. The investor should submit the dispute to a municipal planning tribunal because it has jurisdiction over international investment conflicts. Correct answer, B. Explanation. Classify the dispute first. Judge mindset. Private investor, US, vs government action, Canada. Issue. Policy change affecting profitability. Question. What mechanism is actually available under CUSMA? This is where many candidates fall into a trap. Crossmark why A is wrong, the main trap. The investor can directly initiate investor-state arbitration under CUSMA. This sounds plausible, but it is outdated thinking from NAFTA. Key fact. Under CUSMA, Investor-State Dispute Settlement, ISDS, crossmark largely eliminated between Canada and the US. Crossmark not generally available to private investors. So the investor cannot directly sue the government under CUSMA. Why B is correct. The investor must rely on domestic Canadian courts or encourage the US government to initiate a state-to-state dispute. This reflects the real legal structure. Heavy check mark option 1. Domestic route. Canadian courts. Administrative law challenges. Contractual protections, if any. Heavy check mark option 2. Government route. Ask US government to bring a state-to-state case. Under CUSMA dispute panels. This is the only realistic pathway under current rules. Crossmark why the other options fail. Crossmark C. Impose penalties through contract. Contracts cannot override. Government policy. Sovereign authority. Investor cannot penalize a government unilaterally. No legal basis. Crossmark D. Municipal tribunal. Municipal bodies handle. Zoning. Local planning. They have zero jurisdiction over international investment disputes. Completely wrong level. NPPE exam insight. Very important. This question tests whether you know. NAFTA versus CUSMA shift. Many candidates incorrectly assume ISDS still applies. Final decision rule. When you see investor versus government, cross-border investment, CUSMA mentioned, ask, can the investor directly sue under the treaty? Under CUSMA, Canada, yes or no? One-line takeaway. Under CUSMA, private investors generally cannot bring treaty claims, only governments can. One-line takeaway. Under CUSMA, private investors generally cannot bring treaty claims, only governments can. A Canadian engineering firm enters into a private contract with a US developer. A disagreement arises regarding design responsibilities and cost overruns. The US client argues that the issue falls under international trade obligations. The contract, however, includes a detailed arbitration clause specifying New York law. The engineering firm believes the matter is purely contractual in nature. Both parties are considering escalating the dispute beyond the contract. What is the most appropriate course of action? A. Proceed directly to a CUSMA dispute panel since all cross-border disputes between Canadian and US entities fall under international trade agreements. B. Follow the contractual dispute resolution mechanism, including arbitration under the agreed jurisdiction, as the issue arises from a private agreement rather than treaty obligations. C. Request intervention from both federal governments to interpret the contract and impose a binding resolution. D. Submit the matter to an engineering licensing body in Canada to determine liability and enforce financial compensation. Correct answer, B. Explanation. The correct answer is B. Start like a judge. Classify the dispute. Ask first. Who are the parties and what is the nature of the dispute? A Canadian engineering firm left and right arrow US developer. A issue. Design responsibility plus cost overruns. There is a contract with an arbitration clause, New York law. This is a private contractual dispute, not a treaty dispute. Why B is correct. Follow the contractual dispute resolution mechanism, arbitration under agreed jurisdiction. This aligns with core legal principles. Heavy check mark contract governs. A parties agreed in advance how disputes will be resolved. Our arbitration clause is binding and enforceable. Heavy check mark nature of dispute. A design responsibility equals professional contract issue. A cost overruns equals commercial contract issue. Heavy check mark proper forum. A arbitration under New York law, as specified. A judge or arbitrator will almost always enforce the contract first. Crossmark why the other options fail. Crossmark A. Go to CUSMA panel. A trap. Cross-border equals treaty. A reality. O. CUSMA handles government-to-government disputes. O. Not private contract disagreements. Wrong level. Public law vs private law. Crossmark C. Ask federal governments to intervene. O. Governments do not. O. Interpret private contracts. O. Resolve commercial disputes between companies. No jurisdiction plus impractical. Crossmark D. Engineering regulator. O. Regulators handle. O. Licensing. O. Discipline, ethics, misconduct. O. They do not. O. Award damages. O. Resolve contractual liability. Wrong function. NPPE trap this question tests. This is a classic confusion between type of dispute correct forum, private contract dispute arbitration courts, treaty dispute, country versus country, CUSMA panels, professional misconduct regulator. Many candidates overthink and jump to international law when it's just a contract issue. Final decision rule. When you see a contract clause exists, or arbitration specified, or private parties involved, your default answer should be follow the contract unless there is a clear reason not to. One-line takeaway. Cross-border does not mean treaty. Private disputes follow the contract first. Question 4. Ethical considerations in dispute escalation. An engineer licensed in Canada is working on a cross-border project in the United States. A dispute emerges regarding compliance with differing environmental standards. The US client pressures the engineer to follow less stringent local interpretations. The disagreement escalates, and legal action is being considered. The engineer must decide how to proceed while maintaining professional integrity. The situation may involve both contractual and regulatory implications. What is the best course of action from both ethical and dispute resolution perspectives? A. Accept the client's interpretation to avoid conflict and resolve the dispute informally without documenting concerns. B. Escalate the issue through appropriate contractual dispute mechanisms while ensuring compliance with the stricter applicable laws and documenting all professional decisions. C. Immediately terminate the project without notice and report the client to multiple authorities regardless of contractual obligations. D. Defer entirely to the client's legal team and avoid involvement in the dispute resolution process. Correct answer, B. Explanation. The correct answer is B. Think like an arbitrator judge. Break the problem into layers. 1. Law, regulation, environmental compliance. 2. Contract, dispute mechanisms exist. 3. Professional duty, engineer must act with integrity. 4. Ethics, protect public environment. Document decisions. The best answer must balance all 4, not just one. Why B is correct. Escalate through contractual mechanisms plus follow stricter applicable laws plus document decisions. This is the most defensible and professional approach. Heavy checkmark legal compliance. Engineer must follow applicable laws. If there's ambiguity, safer to align with stricter interpretation. Heavy checkmark contractual discipline. Use formal dispute resolution process. Avoid informal, undocumented decisions. Heavy checkmark professional ethics. Do not compromise standards under pressure. Maintain independence. Heavy checkmark documentation. Critical for liability protection. Professional accountability. Future dispute resolution. This is exactly how a judge would expect a competent engineer to act. Crossmark why the other options fail. Crossmark A. Accept client's interpretation. Violates. Professional integrity. Duty to public environment. No documentation, high risk. Too passive plus unsafe. Crossmark C. Immediate termination plus reporting. Overreaction. No attempt to resolve internally. Ignores contractual obligations. Reporting without proportional steps, not justified yet. Too extreme. Crossmark D. Defer entirely to client's legal team. Engineer cannot. Transfer professional responsibility. Still accountable for. technical decisions, compliance, avoidance of duty, final decision rule. When ethics plus law plus contract overlap, choose the answer that. Heavy check mark maintains compliance. Heavy check mark uses formal process. Heavy check mark documents decisions. Heavy check mark avoids overreaction. One-line takeaway. A professional engineer neither complies blindly nor reacts impulsively. They act, document, and escalate appropriately. Canada challenges a US policy that restricts access to certain engineering services. The dispute proceeds under the formal mechanisms of CUSMA. A panel is established to review the claims and evidence from both countries. The panel evaluates whether the policy violates agreed trade obligations. The outcome may influence future regulatory practices and market access. An engineering consultant is asked about the authority of such panels. What is the most accurate understanding of the panel's role? A. The panel has the authority to directly enforce laws within both countries and impose penalties on private engineering firms. B. The panel provides a binding determination on whether treaty obligations were violated, after which the countries are expected to bring their measures into compliance. C. The panel acts only as an advisory body with no formal influence on the actions of either government. D. The panel replaces domestic courts and becomes the primary authority for all engineering-related disputes in both countries. Correct answer, B. The correct answer is B. Explanation. Think like an arbitrator judge. First, classify the mechanism. This is a state-to-state dispute under CUSMA. A panel is created to interpret whether a country breached treaty obligations. The key question is, what authority does that panel actually have? Why B is correct. The panel provides a binding determination on treaty compliance, after which countries must bring measures into conformity. This reflects how CUSMA works. Heavy checkmark panel role. Reviews facts and legal arguments. Determines whether there is a violation of the treaty. Heavy checkmark binding outcome at the state level. Decision is binding between the countries. The losing country must comply or face consequences, e.g., retaliation measures. Heavy checkmark no direct enforcement on private parties. The panel influences government action, not individuals. This is the accurate, balanced description of authority. Crossmark why the other options fail. Crossmark A, direct enforcement plus penalties on firms. Panels do not enforce domestic law. Penalize private companies. Enforcement happens through government compliance. Overstates authority. Crossmark C advisory only. Panels are not just advisory. Their findings carry formal, binding weight in trade law. Understates authority. Crossmark D replace domestic courts. Panels do not replace courts. Handle private disputes. Courts still handle contracts. Liability, engineering disputes, completely wrong scope. Final decision rule. When you see panel in trade agreements, it does not enforce, it does not ignore, it determines and compels compliance indirectly. One-line takeaway. CUSMA panels don't enforce laws, they determine violations, and governments must act on those decisions.